sounds like we're going to start a couple minutes early, but it's okay, of course, if people are filtering in from class and having to filter back out for 1 o'clock classes. I know some of you have 1 o'clock classes. But thank y'all for being here today. This is our event in celebration of the annual Law Week. So thank you to the Shreveport Bar Association for organizing this event and working with us to come to Centenary again. We are so excited to have them here. I am going to now hand things over to Hema Zuniga, Centenary alumna, to introduce the panel. And if you haven't grabbed lunch, feel free. There's a student sign-in sheet. Thank you. Thank you.
Hey everybody, as Dr. Friesenhan said, my name is Hema Zuniga. I'm an associate attorney at Thomas Waller Jackson & Cole, and I'm the current president of the Gut Lawyer section of the Shreveport Bar Association. I'm here today, as Dr. Friesenhan said, for our annual Law Week presentation. This year our theme is Cornerstones of Democracy, Civic Civility, and Collaboration. I'm joined here today by Allison Jones and Steve Swallow. We're here to present to y'all about some election issues, the Voting Rights Act, First and Second Amendment concerns, and the right to abortion. So Ms. Jones is sitting here next to me on my left. She received her undergraduate degree from LSU in 1982 and her Juris Doctorate from the LSU School of Law in 1985. She currently practices with the law firm of Downer, Jones, Merlino, and Wilhite here in Shreveport, Louisiana. She is a member of the National and Louisiana Employment Lawyers Association, and she's a past chair of the Louisiana State Bar Association's Labor and Employment Law section. She served as the president of 3 different bar associations, including the Fifth Circuit. You don't need to. Are you sure? She's big potatoes. And to her left is Steve Swallow. He is a partner with Thomas Swallow Jackson & Cole. He served on the board of directors of the Caddo Parish Juvenile Court Pro Bono Project, board of directors of the Louisiana Association of Defense Counsel, the treasurer of the Peru Citian, and the treasurer of the Shreveport Bar Association. He's also served as a coach of the Louisiana State Champion and National. Anyways, they are very interesting and educated people, and we hope that you guys will find our talk today interesting. With that being said, we're going to get started with the Voting Rights Act, and I'll turn it over to our panelists.
Okay, well, I think when we talk about the Voting Rights Act, first of all, I want to say that the presentation today was supposed to be with me and Judge Shonda Stone. And Judge Stone had a family emergency, and she deeply apologizes. And so what do you do when something like that happens? Well, you call a friend of yours from law school who's in your class, and you say, you have to be here, and you have to attend, and you have to come. And so let's thank Steve for stepping in at the last minute.
She didn't say it quite like that, but I said, where do I sit? And she's like, to my left, because almost no one is to my left in
Right.
general.
It's like-
Allison leans to the left politically.
I do, and I'll make that very clear, because I understand the presentation last year was 3 white gentlemen who were very conservative, and so you're gonna get a different spin today, okay? You're gonna get a very different spin. When we talk about the Voting Rights Act, I think it's really important to think in terms of the timeline and why voting is so important. If you look at the Declaration of Independence, 1976, and you take it all the way to 1965, when you had the Voting Rights Act, that's 189 years of development in voting and really expansion of voting. The Declaration of Independence said that, governments are instituted by men, and it uses that word, okay? Women weren't even really thought about. Abigail Adams notwithstanding and stomping her foot, women were not included. If you look then at how that developed, it wasn't expanded to all naturalized and born citizens until 1868. Black persons didn't get the right to vote until 1870.
Still no women.
Still no women. And if you look at them getting the right to vote in 1870, and if you ever want a sense of history, and history at your local fingertips, if you look at Colfax, Louisiana, where there was a massacre, that case went all the way up to the United States Supreme Court. Cruikshank case. And that case is known as the Death of Reconstruction. There's a wonderful book called The Day Freedom Died by Charles Lane, and it talks about Louisiana's history and what happened in Louisiana and how that killed Reconstruction. And then you have, from that end of Reconstruction, even though there was a right to vote by African Americans, you have all of the impediments being put in place. And many of those impediments were started right here in our own community. If you look at Homer, Louisiana, that's where the White Citizens Council came into effect. Another book by Adam Fairclough, The History of Civil Rights in Louisiana. Wonderful book if you ever just have spare time to read, which Steve knows that's pretty much what I do all the time. But anyway, we had sort of a restriction of the right to vote. And then, of course, it wasn't really until the amendment was passed where women were given the right to vote, the 19th Amendment. I don't have to really talk about my feelings about that. I mean, I think we should have had that right to vote like from the get-go, but apparently it takes a while for things to evolve and history to evolve.
And then Native Americans even later.
Native Americans even later.
Who knew? They've been here forever, and they don't get to vote until after even women.
I mean, yes, but they didn't create our government, they took their government. Anyway, we get to the Voting Rights Act. We get to the Voting Rights Act in 1965, and we see expansion from that. Even in 1973, I think it was, when it was expanded from you didn't have to be 21, you could be 18. Of course, we all know that was Vietnam in the 60s and everything that was going on there.
But it's Nixon, which is interesting,
Yeah.
because LBJ, Democrats, going left, Voting Rights Act, 65, Nixon's a Republican all the way, and still expanded to younger people.
And it continues to be expanded. You get it expanded where accessibility is something that the legislatures and the courts are caring about. People with disabilities, can they get to go? All the way up until the United States Supreme Court in 2013. And that's where we get to the Shelby County versus Holder case. So one of the things to know about the Voting Rights Act is for states that had a history of discriminatory treatment for voting, that in order for them to approve any policies or changes to the voting situation, the federal government had pre-clearance. They got to review this. Does this pass constitutional muster? Is this something that is going to help enfranchise voters? And we had that all the way up until 2013, when Shelby County versus Holder.
So basically, though, if your legislature passes some new plan or your local government some plan, the federal government gets to review it before it goes into effect to determine whether that appears to be discriminatory or not.
That's right.
That's pre-clearance.
That's pre-clearance. Well, in 2013, the United States Supreme Court decided that
Racial discrimination is over
it's done.
in the United States.
We
Not-
only
not
had
really, but kind of.
189 years of it, and we've only had, 57 years, since, or you have to do the math, but, I was an English major. But they decided that we don't need this anymore. So if you really want to get an interesting critique of that opinion, look at the Ruth Bader Ginsburg dissent in that opinion, because she summed up what the Supreme Court did in these words. She said, "This is like throwing your umbrella away in a rainstorm." And that's what often refer to him as Trolito, or Leo the Torpedo, or we picked up all these names. I mean, he has never figured out a way that he can't can a voting, a right to vote. Well, he throws out all these things and says, look, all these things are threatening the integrity of the voting process. So we don't need this anymore. And what he says is, we're not gonna tell you what to do. We're not gonna have the Voting Rights Act there anymore. We're gonna give you guideposts. And in his opinion, he gives some guideposts. And I think that the dissent in Kagan, who is becoming one of my favorite justices. Now, my favorite justice was RBG, although she should have retired during the Obama administration. And that will always be an asterisk by her legacy. But Kagan is getting there. And Kagan says, in response to this opinion in her dissent, this court has no right to remake Section 2 of the Voting Rights Act. Maybe some think that voter suppression is a relic of history. But Congress gets to make that call, not the United States Supreme Court. That's something that should be done by the legislatures. And she says what is tragic here is that the court has yet again rewritten in order to weaken a statute that stands as a monument to America's greatness and protects against its basest impulses. What is tragic is that the court has damaged a statute designed to bring about the end of discrimination in voting. So when we look at these cases and we look at what's happened since that case, you look at what states are doing to implement voter suppression, voter ID laws, voter things. Why would you do that? Well, you do that for political reasons, because you want one certain party to win. And if you look at states that are doing it, they generally don't like the color blue, they generally like the color red. And if you look at what's going to happen here, with this voting, those are going to pass constitutional muster. So, what can you do as a citizen? And this is going to be my takeaway. I'm going to read from Obama's farewell address as president. Our democracy is threatened whenever we take it for granted. All of us, regardless of party, should throw ourselves into the task of rebuilding our democratic institutions. When voting rates are some of the lowest among advanced democracies, we should make it easier, not harder to vote. When trust in our institutions is low, we should reduce the corrosive influence of money in our politics. When Congress is dysfunctional, we should draw our districts to encourage politicians to cater to common sense and not rigid extremes. And all of this depends upon our participation. Each one of us accepting our responsibility of citizenship, regardless of which way the pendulum swings. So what can you do if you don't like the way the Voting Rights Act is being developed? You can participate in democracy and you can vote.
Alter. So, the basic deal is whichever side has the power and they want to restrict voting in favor of the people that they want to vote their way. So that's the general deal. The limited good news is, in light of all that, you've got these nice maps, but as far as voter restrictions, here, I think you have to show an ID and you have to sign, but you don't have to pay either. You don't have to show, there's some states that say you have to have an ID that's not going to expire, and it has to be federally issued and it can't be expired within 2 months. I don't think we're quite that difficult. But since this has come about, we have a nice map where all these dark areas, they're trying to restrict it even further. At least Louisiana hasn't done anything before to try to restrict your right to vote.
But do those dark areas, do they like the color red?
I said like
Some of them do.
And then there's also this attack on the presidential elections and how they're going to restrict the way to interpret the electors that get sent to vote and confirm who's elected president. And although states are trying to change things up, especially Texas is getting to where they want to say, no matter what all the voters said, the electors that are going to decide the president, they may not have to vote the way the electors said in Texas. But at least, according to this map, Louisiana hasn't taken that up yet. They may be trying, but they haven't enacted anything on that yet. But Allison's right. You got to vote. That's the main thing. If you think your vote doesn't matter, your vote matters. You really need to get out and vote at every chance you get.
And just since that opinion in 2022, in the materials you'll see that over 32 states have pre-filed or introduced over 150 restricted voting provisions. So they're going to try to restrict your right to vote. And that's one of the things that we have to work towards if we're working towards democracy. So we're going to try to give each subject about 15 minutes here, and I added a subject on to one?
Fine, go for it.
The next thing we want to talk about is the First Amendment.
Do we? Before you do that, I think you should mention, so there's discussions, by the way, about felons, whether they're going to be allowed to vote at all. Because lots of states have different rules about if you're a convicted felon, you can't vote, but you might be able to vote after you've been out of jail or you cleared your probation or done some other stuff. It's a state-to-state thing. There's a lot of debate about that. A lot of people on one side don't want felons to vote, a lot on the other side do.
But think about it, if you're thinking about it from the expansion of voting rights, and you think about it from who's a felon and why are they a felon, and you look at our laws and how they've changed and how they've evolved, things that we used to think were felonies, you know, in the early 70s, using marijuana, now we're like, okay, well, we use that for, you know, other purposes. Some felonies are stronger than others, okay? So, and some felonies are in place because they were designed to under the 13th Amendment. If you look at, you could create and you could discriminate against on the basis of race by making something a crime. So there are reasons to expand voting rights for felons.
And we'll skip the deal about the mayor's election challenges.
Have we talked about that? If anybody wants to talk about it. The mayor didn't fill his paperwork out right. He got to run, but I really do think democracy spoke. I mean, I think that people kind of held that against him, whether you were a supporter of his or not. I think if you look at the way that the voting went down, I think that was something that ended up hurting him in the process.
I certainly agree. So Luke, lesson there, fill out your own paperwork if you're going to run for
Yes.
and fill it out accurately. It's
I would
important.
also add that Judge Stone was on that panel that decided that issue whenever it was appealed from the trial court, and that was one of the reasons why I invited her to join and come talk to y'all. But as Allison and Steve has said, fill out your paperwork.
Yeah. All right, so to go maybe then to the First Amendment.
Sure.
There's so much going on in the First Amendment, and we can't cover everything on the First Amendment. There were two really big cases argued recently at the Supreme Court that aren't mentioned in the materials, the 303 Creative, you know, the website case. So many thoughts about that case, can't really go into them here. And then, of course, there was a religious case that was argued by a friend of mine, Aaron Street, just last week or the week before. If you get a chance, you can listen to all those oral arguments online. And you really should, because you get a real good flavor of where these judges are and what they're going to do. The case that Aaron argued had to do with somebody who wanted the Sunday off as part of his religion and what the burden test is going to be for religious discrimination. And all of those, I think, are going to be interesting because if you look at where the court is going and where legal cases are going, you have gay rights, you have reproductive freedom, you have all these issues, and then there's pushback on religious freedom, and they collide. And you're going to have this collision occurring until these issues get resolved either legislatively or by the courts, and that's why you need to participate in democracy. But one of the recent participations in democracy has really tickled me. My girl Zoe. She is elected in Montana from Missoula County. She is the first openly trans woman to be elected in the Montana legislature. If you haven't seen what she's been doing in Montana, it's been really interesting, so Google it after you finish because it's just fun to watch. Montana has put a Senate bill out there that prohibits gender-affirming medical and surgical care for transgender minors. And of course, she's not going to like that. So during the Senate debates over this, after they said their opening prayer, she asked to speak. And she said, if you are forcing a trans child to go through puberty when they are trans, that is tantamount to torture, and this body should be ashamed. And she also made another comment. After she was chastised for that comment, she says, the only thing I will say is if you vote yes on this bill and yes on these amendments, I hope the next time there's an invocation, when you bow your heads in prayers, you see the blood on your hands. Okay, she ain't holding back. My girl Zoe is talking, okay? Well, that got backlash from the House Republicans, and the Montana Freedom Caucus issued a statement calling for a censor. The minority leader defended the representative and said a censor would be blatantly disrespectful and the farthest thing imaginable from a commitment to civil discourse. But they did censor her. They refused to let her speak on any bills, despite the fact that there wasn't a formal censor in place. So, participants of democracy, about 100 of them, showed up at the Senate debate on this bill and started screaming from the balcony. And you can see this on YouTube. It's just fun to watch. I am so tickled by watching this.
It's this week. Oh,
Yes.
It's this week.
Let her speak. And all she did was take her microphone off and hold it up like this and let them listen to the people saying, let her speak. She was not formally censored, but she was not allowed to speak on the bill. And I didn't look up the status
All
of the
she has
bill.
to do is apologize.
Oh, yeah. all
If
do
you
is
apologize, we'll let you talk.
Yeah. Because, I mean, my goodness, you have to talk, appropriately if you're a representative. So why the First Amendment? Why are we talking about that with respect to the First Amendment? Well, you would think that an elected official had a right to say pretty much everything they wanted to say when debating a bill.
But there are rules of decorum. Everybody can't talk about everything and everything they want to say all at the same time, or as loud as they want at all the same times, because you have to run the country or run the state, right?
Yeah, and I will tell you that I kind of see this from two different perspectives, because I think people should have a right to say what they want to say in public with respect to debate, and they should have a right to attack. However, I did serve on a board for a very small town for 24 years, and I was the recipient of having to listen to all of these attacks for 24 years. Listen to people yell and scream about their water or their utilities, or they didn't get their trash picked up, or all that stuff. So the rule is, under the First Amendment, that political bodies can establish a rule of decorum that says as long as you can prohibit disruption of the civil discourse. So my question to you would be, if this case with my girl Zoe went to court, is just holding up her microphone to let them listen to the public disrupting? I don't think so. Were the people in the balcony disrupting? Yes, but isn't the nature of protest to be disrupting? I mean, isn't that what protest really is? So any thoughts on that?
I want to get to the Tennessee 2, or Tennessee 3.
The Tennessee two-step. Okay, that's my girl Zoe.
One second.
Okay.
Before we get to that, I did look this morning on the New York Times, and so apparently they're expected to vote later today on whether she's going to be censored or disciplined for her actions this week. So stay tuned, read your news.
If she is censored, I'm gonna send her a business card.
Yeah, I think the main thing is, though, is the comments about blood on your hands more than waving your deal, so. I don't
Is it wrong to say that? How many people when debating abortion have said you have blood on your hands?
Which is going to get.
Is it okay for one subject and not the other?
Which is going to get to the next area, which is the Tennessee 2, which surely you all have heard about. We have people in the legislature in Tennessee, the state legislature, who are having an anti-gun protest on the floor with a megaphone, which maybe they shouldn't have done. Maybe it's a little bit loud. Maybe it's a little bit too much. But they expelled those guys. And then even
No,
for
they
a
only
worse
expelled
look,
two.
only for a worse look, they didn't expel the third person who happened to be white and female, but they just expelled 2 African American men. Okay, people in Tennessee don't recognize a bad look, apparently. That's really-
We could have said that when they picked the color orange for their team.
And the basic thing is, what's wrong with progressive discipline? If you guys get a parking ticket on campus, we don't expect you to be expelled from campus. If you bring a megaphone up on the floor, you would think they would say, hey, cut it out, or maybe even censor you, or maybe do some kind of resolution, but to expel them, I'm sorry, I thought it was nuts. I thought it was really.
Well, I think a lot of people thought it was nuts, and a lot of people thought it was a bad look for Tennessee. And I think you saw them back all the way from it.
Not the legislature. They got reinstated by the local governments, not by the legislature.
They did.
They don't apologize to those guys at all.
I wouldn't. They're elected officials. They get to do what they want as long as they're not disrupting civil discourse. Is the test. Okay, so you often hear people say, and I do consultations generally on Thursday, and I book them from 9 till 5, and then I go home and have a glass of wine because I've listened to people all day. But you hear people come to you in a consultation and say, but I had a First Amendment right to say that. And the answer to the question is maybe and maybe not. If you work for a public entity, maybe you do. Because the First Amendment only protects against state action. But if you work for a private employer and you post something on your Facebook page that is offensive, they can fire you for that. Now, there are some protections in place about that. So the first question you have to ask yourself is when you say, well, I have a First Amendment right to say that is, who do I work for? We're talking about the workplace, not just in conversations with your friends. As long as they're really good friends, you have a right to say whatever you want. And they're going to forgive you. But if you're not, then they're going to hold a grudge and who knows where you go. But I'm talking about in the workplace. Okay, so the first question you ask is it a public employer? And then there have even been restrictions put on that. There's the Garcetti case, which is a Fifth Circuit case, that says that if you're speaking in the course of your work duties, then that's not protected. But if you're speaking outside of what your job responsibilities are, it's protected. So let me give you an example of that. Let's say you have a police officer who has to go testify in court, and that's part of his job duties. His speech there then is not protected by the First Amendment. But let's say that particular police officer is also a member of Black Lives Matter and wants to go out and protest with his friends, and he's out there protesting, but his police department is really PO because he's protesting against police brutality, and they hold it against him. Well, that type of conduct is not part of his job responsibilities and then would be protected under Garcetti. You also have to look at the next level of the test, which is called the Pickering-Connick test, which is does the language being used rise to the level of disruption? Does it disrupt something in the workplace? So an example of that I have is I recently did a gentleman who wanted to run for office, and he went and told his boss, I'm running against you. And his boss said, well, if you run against me, then I'm going to fire you, and that's your last day out of here. Well, you can't do that because running for office is a First Amendment right. And the boss argued at court, well, if he was running against me, that was going to be disruptive in the workplace. And the court said, no, that's public employment. Yeah, that's just part of it. Now, let's go to private employment. Private employment, you better be careful because you can run your mouth all you want as long as your boss wants you to run your mouth. But if you don't run your mouth, then if you do and it offends your employer, they can fire you. That's why I've always worked for myself. But there are some,
Right, look, you guys are going to work for private employers at some point. She didn't work for herself at first. And you just need to be careful what you say. You're right. You got rights. But if you want to use your First Amendment rights, you may not be working for me that much longer.
Now, there are some protections. You can't just stop at the First Amendment. Like if you, let's say that one of the things that you're saying is, I believe I've been the victim of racial discrimination. Well, Title VII is going to protect you from that. Or one of the things that says, I believe you're violating a state law. Well, you get whistleblower protections for that. But you can't say all those things and say, that's my First Amendment right, because you don't have one if it's a private employer.
The thing that from your perspective I don't think you will think about as much, which is, number one, if you're saying something about me or my office or about something in general in the public, it might make me mad in general personally. That's one thing. But as a business person, I'm concerned if you're on social media and you're somewhere else and you're saying something that's really out there that might offend my customers. It's just a business decision. So again, you got rights. You can use your First Amendment. You can say what you want. But if it's going to affect my business, I'm going to have to address it one way or the other, unfortunately. So, when you work for yourself, all bets are off. You can do a lot of different things. But just keep that in mind when you enter the workforce.
I think the other thing that they asked us to speak upon was free expression with public officials. If you're a public official and you have a Facebook account, and somebody says, I think you're the most crooked public official that exists, and you say, okay, well, you're no longer my Facebook friend, and you block them. Can you do that? Well, that's going to the Supreme Court. We'll see. And I think the issue there is social media has become such a way or a mechanism of us getting our news, Facebook, TikTok, Instagram, all these different ways of, is there, and honestly, to the point and to the detriment of our print newspaper and online newspaper, people don't get their news always from that. So the question becomes is there some public right to be able to critique your public official? And we'll see what the Supreme Court does with that.
And it's pretty interesting because if you're a public official, if you have a public social media presence, then probably people have a right to comment more than if you have your own private site, or even if it's a candidate site that's really not officially part of the government, those people want to put a patrol. You can block anybody you want on that probably. But yeah, it's all in the middle of litigation. It's all going to be resolved in the next year or so.
All right, so that's our 15 minutes on the First Amendment.
You want to talk about guns?
Let's talk about guns. I'm the mother of 2 boys who swore when I had my first son, at the age of 23, that my boys would not play guns, and they would not have guns.
And what happened?
They played with play guns, and they have guns.
They're hunters.
And they're hunters and fishermen and all that kind of stuff. So I just lost that battle. Okay, some battles you know you're gonna lose, all right? Great kids, both attorneys, practice law, do great. You know, what do you do about guns? Everybody has super strong feelings about this. If you look at the Second Amendment, it's probably the most difficult amendment. And some people say it's very clear. Depends on where the comma is, how you read it, all of these different things. But if we look at this from the perspective of the Supreme Court, we really thought prior to 2002 that this issue had been resolved. I mean, we really thought that it had been decided that you could put some restrictions on the right to own guns.
And there were a lot of them. There were a lot of reasonable restrictions at the state and local level, and that they could do a lot of whatever they wanted to do. And then something called Heller happened in the Supreme Court.
Heller happened, and even then, Heller only said, look, you have a right to possess guns within your home. Okay, it's within the home. And the question of whether you could possess a gun outside of the home had never really been reached. There had been over 1,000.
Heller's 10 years ago?
Heller was
2008.
2008, yeah. So there have been over 1,000 cases since Heller, and almost all of the courts have upheld some sort of public carry, gun control laws, you know, or used intermediate. The test there is, do you have a historical right to carry the gun? And it's a balancing test. Does the state have a compelling interest in restricting that right? That's what Heller said. History balanced with the compelling interest.
Whatever that, because that's the new rule they established in 2008, and people are going, what does that mean? Historical context? We're talking about Second Amendment, we're talking about the 17...
Oh, but it gets worse.
Okay, we're talking about way back.
It gets
Historical
way
context,
worse.
what kind of guns did they have when they passed the Bill of Rights?
It gets
Muskets.
All right. So, in 2002, the Supreme Court issued a decision, New York State Rifle and Pistol Association versus Brown, and it has to do with the constitutionality of New York's public carry law.
So 2022, right?
2022, is that what I
You
said?
said 2000.
Oh, 2020.
Last year.
That's why you have friends who've known you forever.
Last year.
Last year. Okay, this opinion, if you ever, I mean, most of y'all, I think there's a phrase that my husband says when I'm leaving notes. He says, TLDR, too long, do not read. Okay, and the opinion is very long. Justice Thomas wrote the opinion. And basically what he did,
Next favorite behind Alito?
I would say I rank him Alito as public enemy number 1, Clarence Thomas public enemy number 2. At least he's bumping up because his private jets and his yachts and all this stuff is so interesting. You know, Crow was asked if he would be friends with Justice Thomas.
Crow is the guy that supplied him with all the trips and the water houses and the big Texas investments.
And he said, would you be friends with Justice Thomas if he wasn't a Supreme Court justice? And he said something to the effect of, well, I don't know. Okay, well, what does that tell you? It's like, what does that tell us? Anyway, Justice Thomas wrote the opinion of Brown, and he says in this, A, not only are we going to take it as you have a right to carry a gun at home, you have a right to carry a gun outside of a home, and we're taking Heller and we're throwing that out the window. Now, it's the burden of proof on whoever is restricting gun control to show that they're not violating the historical right to carry a gun. So what he does in justifying this particular, throwing out this particular restriction in New York, is he goes all the way back to England and he does the history. And I want to say, if you look at constitutional law and you think to yourself, should we have a living constitution or should we be originalists? Well, this is the best case ever for why originalism doesn't work, okay? I mean, he talks himself through England, he goes through the beginning of the country, and then he goes through Reconstruction, and why it was necessary for people to carry guns, and the bottom line is, his belief of all this is, the more guns, the better, we're all safer if we all carry guns, okay? And he might be right, I don't know, I mean, there's only mass shootings everywhere, and I don't know, but he basically argues that all you have to do to strike a restriction is show that it's not historically justifiable. So think about that analysis, because you're going to go back to 1789 to decide whether an AR is something that you can restrict when all they had were muskets. I mean, what the heck did those founding fathers know about these particular type guns we have? So I find the whole case just like unbelievably disturbing. What is not disturbing about that was his opinion, and it was joined, but there were two concurring opinions. One was by Kavanaugh, and the other was by Roberts, I believe. And they sort of pull him back a little bit. And they say, look, that only has to do with the states that say that they may issue these permits. You know, New York had a may issue. Like, if you meet all these requirements, we may give you a permit. But most of the states have a shall issue. And so we're not saying that those shall issue states have to go by this. But let's be really clear about what the Supreme Court does when they do things like this. They put their foot in the door, which they've done with this case, and they're getting ready to kick the door wide open to go to the shall issues, no matter what they say. Breyer wrote the dissent, was one of his last opinions. It was a very gracious dissent. It focused on the statistics and why things have changed since we fought the Revolutionary War, and why things are going to continue to change if we don't do something about this. And Breyer really pushed back on going to Heller. Now the bottom line is, that's what the Supreme Court has said, but I'm going to go back to the Voting Rights Act. It's not really what the Supreme Court gets to say. How did they get to decide what's historical? I think if you had a really well-drafted piece of legislation that put the history in, that satisfied this case, that did something at the congressional level, that it would probably pass constitutional muster. But right now, we don't have that at the congressional level. So that's where we are.
A couple of things to comment on is, look, they restrict guns at courthouses. I think the Supreme Court says we can have guns wherever you want them. They don't want them near courts. They don't want them near legislatures. That's an interesting twist to me. What's the gun policy on campus? Are we allowed to have guns on this campus?
No, okay, so they go in, and that was really interesting in this opinion, because he goes into, we have to have these special safe zones. And guess what Justice Thomas thought was a special safe zone? Where he works, the courthouse. Of course, that's safe. You know, it's like every place else. Like, if you're not in a school, or you're not in a courthouse, or you're not someplace where a judge might be threatened, then you're at risk.
Rules for thee, but not for me.
Yes, yes.
And look, the majority of America, by any poll, thinks that some gun restrictions and some additional gun restrictions is a good idea, especially what you're seeing in the news just about every day. It can't get through the legislature. I believe the vast majority of gun owners, or people that are really gun people, think it's okay to have some restrictions. Somebody should have some training. Somebody might have to have a waiting period. They want to get guns out of crazy people's hands and untrained people's hands and dangerous people's hands. And those are the majority of the gun owners as well. But there's a fringe, the NRA and the other people, they're just like, no restrictions at all, no restrictions at all, because it's a slippery slope, and once you start somewhere, it's all going to go downhill. That seems to be the pushback from the other side.
Well, and I think if you want to go back to the Voting Rights Act, and you want to go back to Obama's statement about citizens and the corrosive influence of politics, you might want to look at your elected representatives and see how much money they received from the NRA, or what their voting record is for the NRA, and why the NRA gets that much power. It's because we want them. And so that's something that you may agree with. You may think, that's what we should do, and that's fine. But if you don't, then you shouldn't let them.
But the people on the other side of your aisle are gonna say, we passed legislation last year. Last year, we had the first gun bill that did anything in the last year. Isn't that enough? I mean, we're doing something about, we're spending money on mental health, we're gonna try to work on some background checks. Isn't that good enough? Oh, and we gotta get better doors on the schools. That's gonna stop everything.
And this is when you get old. I'll be 62 this year, and I drive by schools that I attended, and they look like prisons. I mean, we have basically, the bottom line is, there's got to be some balance here. And look, I'm not telling you I know all the answers to the questions, I just don't think looking back at history is gonna help me. And even then, what gives these judges the right to think they know history better than the historians know history? You know, are they gonna be the ultimate decider of history? That's, you know, it's problematic for me, but there's no question but that society has changed when it comes to guns. And I would ask the people on the other aisle who passed this bipartisan legislation, how many mass shootings have we had since then?
Don't you think the thoughts and prayers are enough? Won't that stop it?
Depends on what you're thinking and what you're praying.
Yes, question for you, audience.
So, historian, I have a question that this is legitimate because I don't understand the sort of distinction that they're trying to make, and this sort of going back to history. So, like, if you look at more contemporary history, when we actually see gun legislation get endorsements, including by the NRA, it's when guns are in the hands of black people. And so, the NRA lobbied for and helped pass gun restrictions after the Black Panthers Party.
Yep.
So it seems to me like we actually don't even have to go back that far in order to find cases in which that well-regulated portion was actually getting like a real hearing. Is that addressed anywhere?
No, he does. Justice Thomas, in that opinion, it's really interesting because there was an amicus brief filed by Black Freedom Caucus or something, who argued that, and they argued that if you go back to post-Civil War and Reconstruction, if African Americans had had more guns, they'd have been able to defend themselves against the massacre that occurred in Colfax. And they turned that on its head, and they basically used that tortured history, which it is, you know, it's terrible history, but they use it for the justification, or at least he does in his opinion, to say, basically, the more people have guns, the safer we are. It's a self-defense type history.
So they're essentially arguing against their own history of.
But what I don't like, yes, what I don't, it turned Reconstruction on its head. I mean, I'm sure there are people reading this going, wait a second, are you even looking at the world I'm looking at? But they're not. And the most disturbing thing about it, now this is only for the May issues, but the most disturbing thing about it was they just took that second text that Heller had of balancing the state's compelling interest, and they said that doesn't matter. We don't even look at that. If it's not justified by history, the Heller second part test is no longer something we have to look at. You have the burden to prove that history justifies your regulation.
And since Heller and right before that, 200 years of focusing on the first part of the amendment was the thing, but after that it's focused on this right shall not be infringed. That seems to be the focus, shall not be infringed. And that's all they want to talk about. If I could encourage any of y'all to listen to a particular podcast, there's something called More Perfect, where they address Supreme Court cases, and there's one about the gun show, and it is fabulous. And there's three main events that gets us where we are. The first one is the Black Panthers in the 60s, where the black folks were policing the police in San Francisco, and they go, we gotta have gun control because there's Black Panthers out there. That was a big event, and then the second big event is the NRA in the 70s became a political force. It really wasn't until then. They got super involved in politics, and then politics is about more guns, and sell more guns. And then the third thing is Heller. That's when Heller came into effect and they decided there's going to be not as many restrictions and the right shall not be infringed. Those are the three things. Fabulous podcast to listen to.
One question in the back row.
Can I ask kind of a general question?
Mm-hmm.
I really appreciate how you have mentioned several times and focused on participation, right, in the process of democracy. One of my biggest concerns right now is the reach of legislation and censorship down into colleges, high schools, and elementary schools, and its impact on our ability to engage young people in civil discourse, critical thinking, and discussion around these important issues, and develop citizens to make informed decisions and to participate. Do you have any thoughts on that?
Well, I think it depends, if you're a private college who doesn't receive federal funds, you're gonna have different standards.
But we're gonna inherit those students,
Oh,
right?
yeah.
So, you know, it's down into K-12,
Yeah.
right? And I can't remember what the number is, but if you look, it's like, you know, it's like quadruple, you know, the number of sort of gag orders that are being proposed
Right.
across the United States. And it's not just those states that you showed earlier. I mean, it is in every state right now.
But I want to go back to, that's more of a First Amendment expression type
Right.
thing. You go back to, can a private school do that? The answer is yes, private school can. They're not a state actor. The First Amendment only applies to state actors. So you get to, are you a public university? Could LSU do that? There would be limited. There would be some limitations on that. And then you can go to Title VI of the Civil Rights Act, which is a student's right to receive an education or property interest in education free of discriminatory conduct and safe environment with dignity. And that's going to be any entity that receives federal funds. So are there limitations? Yes. Look, if you're a private club or school and you don't receive federal funds, you can have that type of censorship. But there are limits on state actors. But, and I hope that answered your question. I've got about, how many more minutes? 15?
15. So
Y'all, I have got to talk abortion. Okay, I've got to.
What's new with abortion?
Well, you know, I used to say all the time, well, I'm not going to vote for that person because that person is anti-abortion or anti-choice. Really, let's put this in perspective. Really, anti-freedom of reproductive health. Let's define it that way because that's what it is. But I can't do that anymore because there really is no right to that anymore. So if you don't like it, you gotta vote. And if you, what we have seen since the Dobbs opinion, and I knew that that wouldn't be the end of the line, that then they're going to come after medication abortion. And so that affects women that maybe, you know, don't want to have a pregnancy, but it also affects women who are endangered by the pregnancy. And so we are talking about a war on women, and let's be clear about that. If you think it's going to end with this opinion, it is not. It is going to go talk about Dobbs, I'll talk about the Danko opinion. The Danko opinion, so what happened after Dobbs? Do you know about Dobbs? Everybody knows about Dobbs, right? Okay, we overrode, you know, decades. I actually, in 1984, and this is one of the weird things you may not even know, in 1984, Justice Harry Blackmun came to speak at LSU Law, and I got to have dinner with him and talk to him about this.
He wrote Roe versus Wade.
He's the author of Roe versus Wade. So I've seen this, like, through my career just change. And I would talk to younger women all the time about the fact that we don't have an equal rights amendment. And if we don't have an equal rights amendment, you can think that there's a Supreme Court case that protects you. You can think that Title VII protects you. You can think that something else is going to protect you. But until you have a constitutional right of protection, you do not have a right of protection. Congress can change. Congress can overrule Title VII. It can become new law. You have seen now that Supreme Court precedent can be overruled. And I would always get some feedback from some women, not everybody, but younger women. It's like, oh, I don't have to be a feminist because those rights are protected. No. Feminist means that you are an independent thinker and that you want your rights protected, and they are not protected until we have an equal rights amendment. But all that being said, Roe got overruled. And we haven't seen that. That stops. All right? So then, after that, we saw that there has been a move to challenge medication abortion. And we've had a lot of forum shopping. They picked the one judge in Texas.
Before you get to that, just think about it, because Dobbs really, the overall thing of Dobbs is, we're overruling Roe, we're gonna let the states decide. Every state's gonna decide what they're gonna do about
No
abortion.
federalism on
rights.
abortion. We can federalize, we can do guns, we can do everything else, but no federalism on abortion.
That's the Supreme Court, until the new case.
Well, the new case comes, and they file it in Texas, and they say, look, we want you to prevent the use of this methylstone, or however you say it, okay? Medication abortion. Okay.
Let's call it medication.
Too old, medication abortion.
And we want you to prevent it nationwide.
And we want you to do it nationwide, all right? Now, there was similar litigation ongoing, but they only limited it, it was only joined by certain states. So you had two competing federal court judgments. You had one coming from Texas saying, can't use this anymore, all right?
Anywhere.
Nowhere, nationwide. And you had one that said, no, you can use it, and there's 28 states, I think, that approve it. It goes to the United States Fifth Circuit Court of Appeals. I do a lot of work at the United States Fifth Circuit Court of Appeals. It is the Court of Appeals right under the Louisiana Supreme Court. It is Texas, Louisiana, and Mississippi. It is the most conservative court in this nation. If you think it's stacked with, well, there's a lot of people who like the color red on it. That's a nice way of saying it, okay? And that's fine. But you're probably gonna get more conservative opinions. And you would think that those conservative opinions would say, oh, no, government regulation, we're anti-government regulation. And that's true until it comes to your uterus, and then they want to regulate the hell out of it. In this particular case, the Fifth Circuit upheld the opinion. So they go to the United States Supreme
She
Court.
left off the part that it's 2-1, it's three judges on the panel, right? It was 2-1 to let it go, and one of the judges was in law school with us in our class. He's not a friend of Allison's, I don't think.
No, he and I are great friends. I know that is not true. He might be public enemy #1 on abortion, but he and I are really good friends. And I see him probably 3 or 4 times a year, and we have dinner, and we enjoy each other's company. He's just wrong.
Wrong about everything.
I mean, what he says in his opinion is, oh, if I do this, it doesn't change anything because this drug wasn't approved until 2016, and so we're just going back to where we were in 2016. Well, I'm sorry, in 2016, we still had the right to abortion. It's like now we don't have it anymore. There's no surgical abortion. It's not going back to 2016. And then the testimony that he relied upon, and when we do have dinner, we have certain glasses of wine, and these are the types of debates we have. I will point out to him, the testimony that he relied upon was that an emergency room doctor testified that when she had to give this medicine from miscarriage, we're talking about women's health, when she had to give this medicine, it caused her emotional distress. I'm sorry, I kind of think that comes with the territory of emergency room doctor. I mean, you have people coming to you with gunshots. Does that not cause her emotional distress? I felt like at that point I had standing because his opinion was causing me emotional distress.
So, to make it a little more basic, so that's the standing argument. They said the doctor could sue because he had to treat these women that had taken this drug and went to the emergency room. If you got in a car wreck with you two, and if I sued on your behalf, I don't have any standing because I don't have anything to do with it.
Unless it caused you emotional distress.
Unless it hurts my feelings, or I was very upset about it. That's basically what they're saying. This doctor who said, this makes me very upset to have to treat these people, that gave them standing to proceed with the case, which
All right.
some of us seem like nonsense.
So it was nonsense. The whole case is nonsense. The Fifth Circuit decision was nonsense. And it goes to the Supreme Court, and they ask the Supreme Court for a stay.
And who's the
So
judge?
because our judge in the Fifth Circuit is my favorite public enemy #1, Sam Alito, who I'm going to see next week. Can't wait to tell him. He stays it for 5 days. And then the whole court has to look at whether they're going to grant a stay. Well, they did. They granted a stay on Friday. And you would think, okay, well, that's fine. There's a stay. Now the drug is still out there. Everybody can use it until the Fifth Circuit rules on this again. And it doesn't go to the same panel. It goes to a different panel. Oh, we just have to decide, maybe there are some, and there are some judges there. We just have to see. What I thought was interesting about it, and this is something that's been pointed out on one of our favorite podcasts, or at least Steve's the one who got me. keyed in on it, and I just have to tell you that if you,
It's the podcast.
it's called strict scrutiny.
Yeah, Trolito.
Yes, Toledo, Alito, Torpedo, all of these things are places that I picked up. Strict scrutiny, and it's hysterical. And the most recent one I listened to pointed out something that I thought was really interesting. In the dissent, the only judge to provide a dissent was Sam Alito. And he opens it up.
About staying the case, or whether we should go ahead and put the ban in effect now or let it roll for a while.
Yeah, he opens it up by saying, you know, I don't really like these shadow court dockets where we do this. Although he's done it 1,000 times and just recently did it on the transgender case, okay? And he goes, unlike my other
He didn't really
appointments.
start out with, you know.
Well, no, he does. He really
It
does.
was the tone of it.
He cites 3 cases, and he cites 3, and the 3 cases that he cites are all by the female justices on the court. So, I'm sorry, it's just a bad look. You're gonna straight up attack the 3 females on the court, and if Justice Jackson had written an opinion on shadow court, I guarantee you she'd have been thrown in there too. And he probably just threw Amy Coney Barrett in there because, you know, he had to make it look even. He goes in, and it's really sort of a petulant opinion. I mean, he really is. But basically what he says in his dissent is, I wouldn't have granted a stay. Clarence Thomas wouldn't have granted a stay. And it looks like we're just doing this. And I think the Fifth Circuit's right. And it wouldn't cause chaos because all it does, and he adopted Kurt Englehart's analysis, Kurt's our friend, he adopted his analysis that said, it just brings us back to 2016. What's the problem with that? Well, if you don't have a uterus, it's probably not a problem. But if you do, it is a problem because now you're not back at 2016. You can't go back to 2016 because they've changed the laws from 2016. So it is a problem. If you're a woman suffering from a miscarriage that threatens your life, it is a problem. And he just glosses right over that fact.
And these guys, and they're all guys, I think, on the Fifth Circuit and the Texas case where it came from. And
Elrod, I think, was on the panel.
They're not scientists, and they're not doctors, and they seem to be rendering a bunch of medical opinions about how drugs are approved and how drugs are developed and what effects drugs have and what effect this has on an emergency room doctor when he has to treat a patient. And some of the rules just don't seem like they're making legal rulings on things. But it's not over yet.
It's not over
It's
yet.
going to be going
And,
back to the U.S. Fifth Circuit for the Court of Appeals, which is based in New Orleans.
And it'll be interesting to see what the Fifth Circuit does with it. And I'm curious, there's a judicial conference of the Fifth Circuit being held in San Antonio next week that I'm going to. All the judges will be there. And I'm just gonna, believe it or not, I'm gonna be quiet. I'm just gonna sit there and listen and try to overhear like what the whispering is, like what are you reading? It's like, to see what they're gonna do, because if I were a Fifth Circuit judge and I just got stayed by the United States Supreme Court, I would be like, let's just not go back up there, okay? Let's just not, because you only had one guy coming out to defend you, and that's not the guy you want to defend you, you know, but that's just, those are my thoughts on it. Now, there are other Fifth Circuit judges who have been put on that court for this reason. Many of those judges have come from the religious groups, think tank groups, and I assure you that if they're on the panel, that you're gonna get this right back up at the Supreme Court. My question to you is if the Supreme Court upheld this type of, ban, where does it stop? This drug was approved by the FDA for 20 years with no effects. Where does it stop? Where does the war on women stop? Because apparently, we can't have government regulation on most things, but we can have government regulation on this issue, and something's wrong. And I think that's it, if time's is out.
Do we have any questions for our panelists? Don't be shy.
I mean, we're not shy about expressing our
We're just
opinions.
giving our opinions, we may be wrong about some of it. Thank y'all for the opportunity, it's nice to see all y'all, and like Allison says, get involved.
Question in the second row.
I think I do have a question. I'm not quite sure how to word it or what my actual question is.
Well, you do your best and I'll try to understand, okay?
So I think it was case before the Supreme Court at this point that it's gone to about both guns and women, and that it I forget which state it was now, the details have lost me, but, they had made law regarding people who had restraining orders being able to get access to guns, and especially, I think, something to do with, like, one of those laws that we recently passed in 2022 had to do with domestic violence
Right,
and
it's in there.
restrictions on that. And the court's comments on it, I don't know if they've come to a decision or not, were.
I don't think
That
there's,
was recently argued.
yeah, they just argued it, yeah.
So I don't have a particular question, I guess I was just wondering what your thoughts on.
If I think it's gonna be upheld,
were.
what's the historical basis for that restriction?
Oh,
I mean, do you think, go ahead.
Can y'all explain to the audience what the case is about? Like letting domestic, sorry, but I'm not gonna do their job. But it was like preventing domestic people.
Right,
If
if you have a
you've gotten a
protective order-
TRO or a protective order entered against you, you are banned or you prevented from carrying a gun.
Mhm. And that's being,
I think the analysis is going to be, under that Boyne analysis, of what's the historical basis for that? I mean, it's absurd to me. I mean, do we think that, Alexander Hamilton was, who are we gonna go to say, oh, well, we have a historical basis for this restriction, that domestic violence wasn't even talked about then? I don't know the answer to the question. I don't know what they're gonna do with that. I have to tell you that, I think that if you look at it, this is a guess on my part, that Thomas and Alito are gonna uphold, or are gonna strike down any gun restriction. That Kavanaugh and Roberts are open to it. Because if you look in Kavanaugh's opinion that just was written, they both reaffirmed, Roberts and Kavanaugh reaffirmed, you can have restrictions on the right to carry guns. And they say that over and over and over, like they're, because it's not like, I mean, I think if Justice Thomas had written the opinion, he'd be like, there can be no restrictions. But he's not, he was disingenuous, and he's like, you can have restrictions, but you have to have this history. Okay, but Kavanaugh and Roberts, I think, have shown that they're open to upholding some restrictions. So that's just a guess on my part, that I think they'll be upheld, but I don't know.
It's different with just domestic violence, restraining orders. That's a little bit different from people that have been convicted of a felony. Like, if you're
Right.
convicted of a felony for that act, that historically, felons can get down. So they're prohibited, and they've had lots of bans, and those are likely to be held up. But, domestic violence protection, that's not necessarily a felony charge, that's not as historical. It doesn't go back that far, so it's a different ballgame.
They really kind of set themselves up for a lot of cases coming up there, or they made a mess of it. That's what I'm gonna say. For 20 years, Heller was working, and now they made a mess of it.
Focus on
But, the other thing is, look, it's so easy for me to sit as a lawyer practicing and say, oh, y'all didn't do that right. It's like, if I was sitting there writing that opinion and struggling with these issues, I would struggle with these things. I think I would do a better job, but I would struggle with them the same. So, remember, we're not in the arena the way they're in the arena. We can critique them, but we're where we are. Although I would tell you, we're in an arena that's really more difficult, because we're having to take these tea leaves that they give us and try to implement it on an everyday basis in the real world.
They don't like it when things blow back up in their face either. Very interesting on Dobbs, there's some comments from Kavanaugh like, this is not going to affect medications, it's not going to affect this, it's not going to affect that. Well, they're coming at it every way they can, so it's coming back up.
So put in the door.
Yeah.
I know people have classic one, but I'm gonna ask one more question, and I know you need to. But, speaking of Kavanaugh's concurring opinion and Dobbs, like, we're not saying people aren't gonna be able to cross state lines to get an abortion, but now states are passing laws that
Right.
prohibit crossing state lines to obtain an abortion. So,
It's going to go back up again.
I guess that wasn't a question.
No, you're right, it's going to be litigated again, and how do 5 Supreme Court justices feel about it? And she's right about the split. You got some that are way this way, some toward the left, and there's 2 or 3 that are in the middle that it's hard to predict which way they're going to go.
And the one we haven't really gotten a feel for yet is Justice Jackson. Because how persuasive is she going to be? I happen to think she's going to be very persuasive.
She's only been there.
But she's only been there a little while. She's getting her feet under her. And, Kagan has been more persuasive. What was it, the argument just recently on religious rights where she was so nice to Kavanaugh. I would be like, it'd be nice to do that. But she was so nice. And it was like, okay, because they build relationships and they talk about these issues, they do this. And the truth is, I couldn't to be nice. If I thought, well, I might get your vote on this case, and I might do this, or we might go here. You know, it's like, it's just interesting to me. I think Justice Jackson's gonna have a real effect on that court, on the dynamics of that court. And I think there are people there that will swing. And I think it's gonna be Roberts and possibly Kavanaugh.
Some things.
Yeah, no, I don't know. No.
Some things.
I
What we
think-
need to do is for some of them to retire. Term limits for the US Supreme Court.
You say that now.
Age-
We don't know. And this is, you know, if they retire too soon. Look, this is the asterisk by RBG's legacy. She should have retired during the Obama administration. I'm a huge fan of RBG. I have a crochet doll of her. I have her quotes everywhere. She should have retired because of the fact that she died when she died. You don't have any control over that, but you do have control over whether you're still in office or you're still an appointee. That's how we got where we are on the Dobbs case.
Yes, that's how you get to a conservative majority.
That's how you get to a conservative majority. And you can control that. You can resign in time for your political party's president to appoint somebody.
Unless you're Merrick Garland.
Well, you're appointed at the wrong time. I said in time.
Yeah.
It has to be in time. And now, in time for Democrats to get appointed is 2 to 3 years. In time for Republicans to get appointed is like 90 days.
Right.
It's like different rules. Anyway, I know that we've all expressed our opinions. I appreciate you being tolerant of our opinions, even if you perhaps disagree. One of the things that's so beautiful about democracy is we do get the right to share this. If I had a private employer who heard some of the things I said, they might fire me, which is why I don't have a private employer, so I can be who I am. But you know, if you have a dissenting view, and I challenge you to always question things that you hear and think about them critically, go and find a way to justify that dissenting view, and then vote that way too. Participate in democracy that way. That's what democracy is all about.